Good afternoon, everyone. And thank you for joining our webinar, Accessing Charitable Funding as a Nonprofit. My name is Benjamin Miller, and I'm a policy advisor and lawyer here at the Ontario Nonprofit Network. If you're new to the Ontario Nonprofit Network, or ONN for short, welcome. We are the provincial network for Ontario's more than 58,000 nonprofits and charities focused on policy advocacy and services to strengthen Ontario's nonprofit sector as a key pillar of our society and economy. If you're already a member of ONN, welcome back and thank you for your support. Our public policy research and advocacy work would not be possible without you. If you experience any technical difficulties during the webinar, whether or not you're a member, you can type the issue into the chat box and our team will respond to you as soon as possible. We encourage you to ask questions through the Q&A box because they're recorded, differently in Zoom as a result of that. You're also welcome to share comments and learnings on social media. Spread the knowledge wealth around. To answer our most common question, you will absolutely receive an email with the recording, slides, and resources in 1 week. Okay. To ground our webinar today, I want to begin with acknowledging that we are meeting on unceded and unsurrendered land that has been inhabited by Indigenous peoples from time immemorial. The ONN office is located on the traditional territory of the Wendat, the Haudenosaunee, and the Mississaugas of the Credit. This territory is part of the Dish with One Spoon Treaty and is also covered by the Upper Canada Treaties. And as I'll reflect in a couple of moments, today fundamentally we're talking about what it means to share resources between charities and non-charities, but we can think more deeply about this idea of what it means to share resources in a way that is sustainable for all, that is equitable for all, and that respects the ways the resources have been shared on this land since time immemorial. Although the nitty-gritty of the Income Tax Act is not, a great way to ground ourselves in those deeper values, I do encourage people to keep them in mind as we go through today's discussion. I am not in the office, but I am still in downtown Toronto, so on these same lands. I'm grateful to live, work, and play on and within this treaty and traditional territories of the Mississaugas of the Credit, the Wendat, and the Haudenosaunee. At ONN, we believe that as nonprofits, we must take seriously our role in responding to the Truth and Reconciliation Commission's 94 calls to action, and that each of us has a distinct role to play in furthering reconciliation in the same way we have a distinct role to play in each of our communities. Before I begin my presentation, I would like to invite Deli Alban Reina, the Director of Grants and Community Initiatives at Laidlaw Foundation, to say a few words. ONN is very grateful to Laidlaw Foundation for their support of our work on non-qualified donees and qualified disbursements, what we're here today to talk about, and many other initiatives. This has been a long time coming, so thank you so much to Laidlaw.
My pleasure. Thank you for having me. So as Ben said, my name is Aldeli Albanreina. I go by she, they pronouns, and I am currently at Foundation House. And one of the things that at Laidlaw Foundation, we've been really talking a lot about and also sort of actioning as well is the importance of funding non-qualified donees. For us, one of the things that we often think about when we look at philanthropy, but more so decolonizing philanthropy, is thinking about where philanthropic wealth was amassed from, right? And so we're talking about sharing resources, we're talking about a lot of these things. We also know that wealth was amassed on the backs of Black and Indigenous folks, particularly in this country as well. And so a way that we look back into the importance of doing funding to non-qualified donees is because we know that a lot of Black and Indigenous organizations don't tend to be registered charities. They tend to be grassroots organizations or registered nonprofits, which still, and Ben will talk about this, but will go into the non-qualified donee as well. For us, it's also related to trust-based philanthropy, and we think of wanting to put back power and wealth into the hands of communities, and who better than to let us know what works best for them than communities themselves. And so whenever we talk about trust-based philanthropy or participatory philanthropy, we evidently have to think about how does this impact non-qualified donees, and especially funding non-qualified donees through a partnership with what we call an organizational mentor, so a charity, but going more than a transactional kind of relationship, right? And wanting to have that mentorship piece with it as well. One of the things that we worked on, and I'll look for the link and put it in the chat as well afterwards during Ben's presentation, but the McConnell Foundation, which is based in Montreal, invited Laidlaw Foundation as well as the Chagnon Foundation and In Spirit to come together and create a toolkit for other funders that were similar to us, so private funders and family foundations and other kinds of funders, to understand what it's like to work with non-qualified donees, because some of these foundations don't yet do that kind of work, and so really trying to influence them to get to the point of like being able to work directly with nonprofits and or grassroots groups as well. And then obviously we've heard a lot about the CRA guidelines and how that was impacting the drafts, especially were impacting the state of funding for non-qualified donees quite a bit. And so we did quite a lot of conversations with the CRA, especially around, we are a youth funder, Laidlaw's a youth funder. And so when the CRA had drafted their risk, there was like a risk table, and youth as a category was considered a high risk. And we were like, absolutely not. You're going to have a lot of organizations not want to fund youth-led either organizations or initiatives. And so they finally took it off. And then we also advocated for the ceiling to be higher in terms of like how much money was considered a high-risk project or grant. So things like that, those are kind of things that we do. We try to influence the philanthropic sector a little bit. Oh, thanks, Kavita. She added the toolkit in the chat. So that's great. And yeah, so basically that's the kind of work we've been doing, and we just try to influence the rest of the sector to also continue to fund non-qualified donees.
Thank you very much. This webinar is part of a suite of resources, such as the one my colleague Kavita put in the chat to help influence nonprofits to put themselves forward for funding that charities making available to be able to more effectively and more efficiently comply with the rules that are expected of charitable funders when they work with nonprofits, but also to give you the information you need to help you make the case alongside Laidlaw and others to funders who are currently thinking, are we going to do it? Are we not going to do it? Are we going to adopt this framework? To help you make the case to push them over the edge a bit and to encourage them to start funding, more expansively and inclusively of non-charities. So with that in mind, let's jump in. I'm going to present some information to you for the next 35 minutes or so. We'll then have a question period. Et pour notre collègue francophone qui nous joignent, si vous avez des questions en français, ce serait mon plaisir de répondre en français. Mais malheureusement, la présentation serait en anglais. So the presentation will be in English, but I'm happy to take questions in French as well. So with that, I will share my screen and we will get started. So Here's the guidance itself, and I always like to show people the guidance product itself. It's not behind a paywall. It's not behind some kind of secret password. You can go and read it yourself. But what I'm about to present will be a summary of what you can find in that guidance with some explanations. So I'll go over the new rules. I'll compare it to the pre-existing rules called direction and control that governed how charities work with non-charities. I'll look if you're a nonprofit thinking about becoming a charity and you wonder, is it still worth it given that these new options are available? I'll go over the pros and cons of becoming a charity under the new context. And then I'll speak broadly about how to talk with funders about overcoming some of the barriers and hesitancies to this more inclusive approach to funding. Uh, as I spoke about earlier, coming from dish with one spoon territory, I invite us all to think about what does it look like to ensure resources are more widely and peaceably shared. All right, so some disclaimers. As a lawyer, I'm very fond of disclaimers. I always give at least three. So here's one. Everything today will be general legal information. It is not legal advice tailored to your specific situation. And I would just add that this is an evolving area of the law. So not everything is going to be certain. Things are going to be tested. And that's both a good thing and that it leaves room for experimentation. But if you're looking for certainty, you won't always find it. Number two, this is a high-level overview of the guidance I showed you moments ago, CG 032. It's not comprehensive and it does not address other areas of law that may affect the work you do, such as contract law, partnership law, etc. I note that we have some people joining us from outside of Ontario. I'm licensed to practice in Ontario. This is a federal area of law, but it's a federal area of law that may interact with provincial laws that affect you where you are that I have no qualifications to talk about. And then finally, today's presentation is about law. It's not about the many other things that go into making partnerships and agreements work. We've already heard about trust-based philanthropy. Trust is not something you can mandate into existence. It's something that comes out of, rich and powerful relationships. And that's outside of the scope of today's session. We'll be focusing more on the technical elements. All right, so some key terms to make sure we're all on the same page as we move forward. Non-qualified donee, or NQD. This is a term or an acronym you may have seen thrown around already. So from the Income Tax Act perspective, so it's the Income Tax Act that regulates registered charities. It's the Income Tax Act that gives the ability to charities to issue tax receipts to their donors, which gives a tax credit to the donors. Registered charities are part of a group of organizations that are capable of issuing these tax receipts called qualified donees. As far as the Income Tax Act is concerned, although provincial laws may affect this differently, as far as the Income Tax Act is concerned, registered charities can give money and resources to other qualified donees, no problem. There doesn't need to be strings attached. There don't need to be complicated agreements. They can just make a gift to another qualified donee, which is typically another registered charity. Where things get complicated, a bit more complicated, is where registered charities want to work with organizations that do not qualify as qualified donees, referred to as non-qualified donees. The most classic example of this would be a nonprofit organization that does not have registered charity status. Okay, and that's what the situation that most nonprofits are in. So when I use the term non-qualified donee for our practical purposes, I'm basically referring to all those nonprofits and grassroots groups that do not have registered charity status. Qualified disbursement, or QD, or a grant. So the new rules under the Income Tax Act allow for charities to give money and non-money resources outright to a non-qualified donee. In the form of a gift or making it available, or however you can think of how one charity might make resources available to a non-charity. The qualified disbursements guidance makes it potentially possible. Okay. Um, the To make things simpler, the Canada Revenue Agency, which is responsible for administering the Income Tax Act, has chosen to call this giving money or other resources or making it available, has chosen to call this granting. The term is a bit unfortunate because, in the nonprofit sector, we use the term granting more generally to refer to, one entity funding another entity. But the way I'm going to use the term granting is to mean basically making any kind of resource available any kind of way, whether it's licensing, renting, lending, giving, gifting, donating, whatever you want that's going to come under the term granting when I use that term in this presentation. Okay, thirdly, guidance product. Guidance products refers to the policy positions that the CRA publishes on their website. These policy positions reflect how the CRA thinks about the Income Tax Act, how the Canada Revenue Agency thinks about the Income Tax Act, and therefore how they plan on enforcing it. The guidance products, the things they publish online, are not law. Okay, it's their view and interpretation of what the law is. There have been times when the CRA has been challenged in court, and a court has said things that have caused the CRA to go back and have to change their guidance products. With that being said, guidance products tell you what to expect from the CRA, so that if you're planning to do something other than what the guidance product said, then there's going to need to be at least some back and forth and some explanation about why the regular rule, shouldn't apply in this case. Okay, so it's important both to know that you're not entirely restricted by everything that's said in the guidance product, but if you're looking for the simplest, most straightforward process, you can look to the guidance products as a place for what you can expect from the CRA. Again, the guidance products we're talking about today about charities making grants to non-charities is called CG 032. Okay, and then finally, direction and control. Direction and control refers to the collection of rules that existed before the recent changes to the Income Tax Act that governed how charities could work with non-charities. The basic idea was that if a charity was going to do charitable work, there were two ways to do it. Either one, giving to another qualified donee, so making a grant to another charity, or number two, doing it themselves. So the only way that a charity could work with a non-charity is if somehow its work with that other charity was still a version of the charity doing the work itself. Sounds counterintuitive, right? If they're getting the non-charity to do it, how is it they're doing it themselves? Well, the answer to this question that the CRA has offered for decades is the charity has to direct and control the resources that it gave to the non-charity every step of the way. So even though the non-charity might be carrying out the work on the ground, even so, it is the charity that calls the shots and takes credit at the end for the work. Obviously, if the person who's not doing the work on the ground gets to call all the shots and take credit at the end, that doesn't sound very fair and equitable. So for decades, especially in the international development sector and in other sectors, there have been advocates within the charitable and nonprofit sector that have tried to change these rules to something less colonial, more equitable than the direction and control framework. I want to stress that if the system that I'm going to describe to you today does not work for you for whatever reason, if qualified disbursements do not work for you, direction and control is still available. So that was not taken out of the Income Tax Act. That's still a way that charities and non-charities can work together, and it does work for some. All right. So an overview of what the new rules require. What a charity has to make sure happens if they want to work with a non-charity, if they want to grant to a non-charity. So firstly, the activities that they grant for needs to support the charity's charitable purpose. So it's not enough that the activities they support are just good activities. It's not even enough that the activities they support would be considered charitable activities. Those activities need to specifically support the charity's own charitable activities. Now, many foundations have charitable purpose that say that their purpose is to grant to other qualified donees. Obviously, granting to non-qualified donees does not support granting to qualified donees. So, many foundations are in the position now, if they're interested in exploring these new rules, in having to think about, okay, what are our substantive purposes actually? Are we trying to advance education by, building programs for youth? Are we trying to promote health by, ensuring medicine is available to certain communities? What is our substantive purpose? Not just the general catch-all purpose of granting to other qualified donees. What that means for you as a potential grantee is you need to understand what your potential funders' charitable purposes are, and you have to explain to them how the activities that you are proposing further that specific charitable purpose. Point number 2. Charities that are considering funding non-charities need to vet those non-charities. And they need to basically vet them for 2 things. Number 1, trustworthiness, and number 2, capacity or capability. In both cases, what they're looking for is your trustworthiness, not to use the resources that you're given for purposes other than the charitable purposes, and your capacity to carry out the activities that will further the charitable purposes. So the guidance gets into lots of details about how this vetting happens and what the charity will look for and what documents they might ask for and so on and so forth. But what it comes down to at the end of the day is 2 things: your trustworthiness, that you're going to use the resources properly, and your capacity to use them effectively to further the charitable purpose. Now, funders already vet their fundees, it's in some cases a great deal. So this is not at all unusual within the charitable sector. This is what charitable grantees often have to go through. If you're a nonprofit with experience receiving grants, for particularly government grants, you will likely already be used to having to go through this kind of vetting. Now, it's important to note that the CRA acknowledges that the charity and non-charity may already have a good relationship. And as a result of having that relationship over many years, they may already know a lot about each other that will help do a lot of that work of vetting. So you don't have to, recreate all that work and imagine that you've never met each other before. As long as the charity documents its rationale and evidence that the organization is at the end of the day trustworthy and has the capability to do what they say they're going to do, then all that history you have together as organizations can be very important. So, for example, the Ontario Nonprofit Network, which is a nonprofit, not a charity, has worked for years with Community Legal Education Ontario on a project called Nonprofit Law Ontario, which is a charitable project which advances education. So, when it was time to share Clio's resources with ONN, when the project moved over to ONN, our many years of history working together created a rich record in which Clio could be assured that ONN both had the capacity and was trustworthy to use the Nonprofit Law Ontario resources properly. Okay, then the next item that is a requirement in almost all cases is a written funding agreement between the charity and the non-charity, and we'll go over what some of the common provisions are. But I'll just note that these are very standard provisions for any funding agreement. So if you have experience receiving funding from any source, you're likely to be familiar with these types of funding agreements. We'll go over what some of the key provisions are. The charity not only needs to ensure that you have used the resources for exclusively charitable purposes, they then need to be able to prove that to the Canada Revenue Agency, to the CRA, if the CRA ever audits them or checks, which might be, years later. So it's important that you keep records in a way that would allow the charity, if they're asked, to be able to prove, yes, we used our resources exclusively for charitable purposes. Additionally, and this has already been alluded to, the CRA wants charities to assess the risk of posed by providing resources to a non-charity. And it's not that because something is high risk, they're not allowed to do it. On the contrary, they're still allowed to do it. But if something is higher risk, that maybe the resources might not be used properly, the charity is going to have to take additional steps, be more vigilant, ensure there are more safeguards. And these are things like having a more regular communication schedule, or not releasing all the money at once, releasing it in stages, all things that might make sense for, quote unquote, riskier projects. For example, if the project is larger, more complicated in an area where communication isn't always, easy to have, etc. So we'll talk also about how a charity will be assessing you to determine what your risk level might be as an organization, or what your proposed project's risk level might be. And then I'll talk about shared platforms, which are close to ONN's heart, and how this new framework affects shared platforms. Okay, activities for charitable purposes. So charities can only grant for activities that further their own charitable purposes set out in their governing documents. And interestingly, if you want to know, okay, what is this funder's charitable purposes, you can actually order their governing documents from the Canada Revenue Agency Charities Directorate. So what counts as a charitable purpose? Relief of poverty, advancement of education, advancement of religion, and other purposes beneficial to the community in a way that the law, meaning the courts in the past, have regarded as charitable. That's things like protection of environment, promotion of animal welfare, promotion of health, services to youth, services to the aged. There are many other categories that are in this fourth catch-all category. So you need to understand what category your funder fits in. You need to understand what the law, how the law defines that category, and be able to make the case for how your activity fits into that particular category. Now, if the funder, is a communicative funder, they will explain all these things in the funding application. But if they're not, you know how to do the research. You know how to do the research yourself potentially. What I really want to stress is not all good work is charitable. You may be doing really important work in your community. It doesn't necessarily mean that from a legal standpoint, it would be considered charitable. Okay, vetting grantees. So the funder must look at your trustworthiness to use the charitable resources properly and your capacity to carry out the planned activities. So what might they ask you for? Number one, your official purposes and mission, not just what shows up on your website, but what shows up in your governing documents. So if you're an unincorporated group, do you have a constitution that you can provide? If you are an incorporated nonprofit, do you have your letters patent and your bylaws on hand? Number two, they might look at your programs, both your proposed programs and programs you've done in the past. Number three, your history. And this might include both, what you say on your website and your social media profiles and so on. But they also might do their own research and find news articles about you, or blog posts and so on. So be mindful of what's out there about your organization. And this dovetails well with your reputation. They could speak to other people about your organization. The staff. So it's not just your organization that they're looking at, but if there are key staff members on a project, what's that person's background in this field? Do they have the expertise? Do they have the record or reputation? Have they been involved in scandals in the past? All of this might be relevant. So be mindful, when you assign staff, how you choose, what staff or what volunteers to put on a given project. Associated individuals or entities. So if you're not doing this alone, if you are partnering with other grassroots entities or other organizations, that's great. There are strengths in our network, right? But that information is also going to be relevant to the funder to understand how their resources might end up being used. Again, they might look at your experience and capacity, particularly in doing projects like the one you're proposing. And in kind of a catch-all category, any potential use of the charity's resources. So what are you planning to do with it? So that might look like a financial plan, that might look like a program schedule, etc. Okay, so how might they look at all this? How might they get all this information? So they might do independent research, like I said, news articles, websites, etc. They might do in-person visits, and that's actually a great opportunity for relationship building. They might do virtual meetings. They might do requests for information from you, so ask you for materials and so on. They might look at or ask for reports from past grants, or ask for letters of reference or support. Okay, funding agreements. So except for one-off grants that are under $5,000. So this is the kind of exceptional case where you wouldn't necessarily need a written agreement. CRA recommends a formal written agreement in basically all cases between the charity and the non-charity. And what I would say is you could look at this as so much extra paperwork, or you could look at it as a meaningful opportunity to make sure everybody's on the same page and to articulate our expectations clearly. I, as a lawyer, have regularly seen how people who are acting in good faith and who all want the best for a given organization or project nevertheless come into conflict with each other simply because their expectations were not clarified from the beginning, so they run into confusion, etc. So funding agreements, yes, they can be a drag, but they can also be a meaningful opportunity to help set the stage for clarity and a positive relationship going forward. So what might a funding agreement include? Number one, stating your intentions to make a grant. That the goal here is for the charity to make a grant as defined in the qualified disbursement rules. They're not trying to do direction and control. They're trying to do qualified disbursements. Number two, the start and end date. And that doesn't need to be hard and fast. It could be defined as we're starting now, we're going to check back in at this point to see if we want to extend. These start and end dates can be very useful in defining your obligations to each other so that's not open-ended and unclear, and people can't just constantly be asking for things when you thought it was over. Number three, the full legal names and physical addresses of the parties where possible. So note, if you're an unincorporated association, it will be an individual signing this agreement on behalf of your unincorporated association. The association itself doesn't have a legal existence, so it's that individual who is kind of responsible for the agreement. Number four, grant activities descriptions and charitable purposes. What you're proposing to do and why? How does it further the charity's purposes? Number five, location of the activity. So this doesn't have to be a specific address. It could be a region. It could be a country. You can be as specific or as general as you need to be. Number seven, payment schedule and conditions. So as I mentioned, if it's a small grant, if it's a low risk grant, then maybe it makes sense to disperse all the money at once. But if it's larger, if it's more complicated, likely in many cases, it will make sense to cut it up over periods and maybe have certain deliverables by certain times before additional money is given. From your perspective as a potential grantee, think about what that means for your cash flow. I think I'm on number eight, terminating the grant. So under what circumstances will you part ways? And this is really important to think about at the beginning of a relationship. It's not necessarily a bad thing, but the situation can change, the circumstances can change, and having clarity about how much notice you need. Is the funder going to provide coverage of severance pay if you need to let people go as a result of losing the grant, etc. Thinking through all those terms ahead of time can help give you a cushion at the end of that relationship if it's possible. Number nine, returning unused resources when required. So that money is supposed to be used for charitable purposes. So if you did not use it for the charitable purposes as part of the project, you don't just get to keep it, right? And you can't financially plan in that way. You either need to use it for some other activities that would further the same charitable purposes, or you need to give it back. And it's on the charity to work that out with you. So if they haven't turned their mind to that, this is something you may want to think about with them. The fact that resources can only be used for charitable purposes, you want to make that clear in the agreement. The timelines and frequency of financial and progress reports and just communications. How are you going to communicate in general? Are you going to have online meetings, in-person meetings, etc.? record keeping, and the agreement has to allow for some way for the charity to assess your compliance. Um, and I should note, has to allow for the CRA to be able to assess the charity's compliance. So this doesn't have to be punitive. It doesn't need to be investigative. There are respectful ways to ensure that you're providing the records and documenting things, and people can check in a way to really make sure the resources are being used for what everyone planned to use them for. And then finally, official signatures and dates. And it's not specific who necessarily needs to be the signing authority. So it's based on your own policies. Okay, so some key provisions. Describing the activities. Obviously, that's pretty crucial in the agreement. What are you actually going to do with the resources? Whether it's money, whether it's intellectual property, whether it's space, whether it's real estate, whether it's getting covered by insurance. What are you going to do with these resources? Consider answering the following questions. How will you ensure accountability for the resources? What is the charitable activity and the charitable purposes it furthers? What are the deliverables and performance objectives? So how will you know if you've succeeded? Where will the grant activities take place? Will there be partners, contractors? Are you getting others involved? What is the public benefit in what you're doing? How will you ensure there is no unacceptable private benefit? So that means that there's no one who's getting more than would be justified by what is necessary to further the charitable purpose. And when will the grant start and end? Okay, so you don't need to just set out all these questions and then answer them. You can answer them in a natural kind of flowing way as you describe what you're planning to do with the resources. Reporting requirements. So this would include final reports with supporting documentation, interim reports when appropriate. So, if it's a short-term grant, it may not be appropriate to have both an interim and final report. A final report may be enough, but if it's a longer-term grant, it often will be appropriate to check in with some interim reports. That may not need to be as robust. Interim reports where appropriate with supporting documentation. Records of communication by telephone, video conference, and email. So one of the ways in which the CRA has tried to be more flexible in this guidance is to show their openness to recording communications between the parties in ways other than minutes and records and financial statements and so on. If you're having a Zoom meeting, a transcript and video recording may be sufficient to document, what information was shared in that meeting. Consider who's going to be on these calls, what level of privacy do they want, etc., when sharing these types of records. Photographs or videos of the program, so all those smiling children or what have you. Audit reports. So there's no hard and fast requirement that the finances of this specific project be individually and independently audited. But if there is some kind of, audited financial statements or, financial record, external financial accountability, that would be quite relevant, especially if, the funder's asking for that. On-site visits from the charity's staff, where do you expect them? For example, due to important cultural or religious festivities, your organization may really not want to have the funder visit during a given period of time, and they may not want to visit, but they may not have the cultural sensitivity. So thinking about how to set boundaries around, charity staff visiting, etc., can be a proactive moment of intercultural education that I've seen between funders and fundees. CRA recommends always getting a final report with supporting documentations. All these other elements that I've just listed are kind of case specific. CRA recommends always getting an interim report with supporting documentation for longer term and higher risk grants. Okay, payment schedule for longer term or high risk grants. Installments, CRA generally expects installments to be based on progress. So you will want to generally be showing, how are we achieving our goals? Secondly, payment schedules will generally include an opportunity for the funder to withhold funding if they are not satisfied with the progress or if there's any kind of issue or question of how the resources are being used. And then finally, some kind of termination provision. Again, clearly articulating under what circumstances both parties, not necessarily just the funder, could terminate the relationship or agreement. Again, think about your cash flow. Be careful about your cash flow. Think about how you can build in notice periods that might help ease the shock to your cash flow if you're really relying on this grant. Okay, keeping records and reporting. So, how are you expected to keep records? You're expected to track funds separately. Okay, and this is a kind of hard and fast rule the way it's presented in the CRA guidance. It doesn't require you to have a separate bank account, just track the funds separately. And secondly, you need to report in enough detail to allow the funder and the auditor of the funder, if they get audited, to assess your compliance with the grant. So this is why it's so important to track any funds or any resources separately, because if it's mixed in with other projects which don't necessarily need to be charitable, it's going to be confusing what resources went to what. The charity, so your prospective funder must report the grants that they make to non-charities on their T3010. That's their annual information return. And for grants above $5,000, this includes the name of the recipient, the total for the year, and the purpose of the grant. And this information becomes accessible publicly. If there is a safety concern, you can talk with the funder who can make a special request to the CRA as to why the information should not be public. But the default is this information will be made public. So especially if this grant is being made to an individual or an unincorporated association, so the individual is receiving it on behalf of the association, they may not want their information out there publicly. So this is a conversation that you should feel empowered to have with your funder at the outset, so there shouldn't be any surprises down the road. Okay, how might the charity assess risk? So here are some of the factors that the CRA encourages them to look at. The charity's own experience with funding projects like this and non-charities will impact the risk. So if they are inexperienced, that will also make a project higher risk. So it's not just about you. Secondly, your experience, both in general in managing projects, but also in projects specifically like the one you're proposing. The more extensive that experience is, the lower the risk. Your purposes, how aligned are they with the charities? If your purposes are basically charitable, but you just don't have the funds or capacity to apply for charitable status, that's going to be much lower risk than an organization whose purposes are completely different from the charities and are mostly or completely non-charitable, and you're just kind of applying for this one-off project that happens to be charitable. So think about the alignment between you and the funder. There's actually an inherent disincentive to kind of chase grants from funders that don't really align with your mission. The governance of the grantee. So, do you have a clear decision-making structure within your organization? Is it clear who reports to who? Or are there clear accountabilities, etc.? The clearer and more comprehensive your internal rules and governance are, the lower risk, generally speaking, it will be regarded from the funder's point of view. The grantee's regulation and oversight. So if you're in a highly regulated field, so you're incorporated and you're also, let's say, you're in healthcare or childcare or something like that, so there are even additional layers of regulation, then that's going to be lower risk than an unincorporated association, which there is no clear legislative framework that governs unincorporated associations. And this is especially true if you're operating outside of Canada, which may in a jurisdiction that may not be as regulated. Private benefit concerns. So if it's you and your cousins or whatever, then there might be an additional risk of private benefit, or if it's all one person, or if it's you partnering with a for-profit company, especially if that for-profit company is related to you in some way, then those are all red flags that it's going to be a higher risk project, that the resources might be misappropriated. But if you're an organization that has lots of checks and balances, and there isn't really a concern that anyone in particular is going to be making, a ton of money from this beyond what they would contribute to the project, etc., then that's going to be lower risk. Location of the grant activities. So inside Canada and or in a country that is stable, has in a strong infrastructure, and the charity has a strong presence. I totally acknowledge that there are ways in which this language is quite coded and may even be discriminatory against, for example, the global South or lower income countries, etc., in painting them as inherently, higher risk as opposed to, for example, Western Europe or Canada or the United States. Um, be that as it may, this is how the CRA is thinking about how the charities should assess risk. So the location of your grant activities will inform this risk assessment. The key thing is context is everything, and this is just one among many factors. Okay, so it's all in how you tell the story about what the risk level is. No single factor is absolutely determinative. Well, I should say there's one single factor that the way the CRA writes about it is determinative. We'll talk about that a bit later. Grant amounts. So earlier we heard about the advocacy to increase the ceilings. So this is what that meant. So grants below 5,000 are considered low risk. 5,000 does not get too much these days, right? 5 to 50,000 medium risk. Again, 50,000 not very much these days. Anything above 50,000 considered high risk. So most grants are going to fall into this high risk category. The thing to remember is that the amount is just one factor among many. It's all in how you frame the context, how you tell the story. The nature of resources being granted. So non-cash resources that are likely to only be used for charity. So for example, textbooks or medicine, these have an inherent connection to a charitable purpose, are much lower risk than, for example, real estate. And this is an area where the CRA says if a charity is gifting somebody real estate, it's inherently high risk because it's going to be there, potentially forever. And it could be used for lots of things, not just charitable purposes. So that is one factor that there's no getting around it. The CRA regards it as high risk. But in all other cases, I would say there are opportunities to contextualize and lean on other factors and so on. Even if you have some factors that are high risk, you can still make the case to treat the grant as a medium risk activity or lower risk. The longer the grants are, the riskier it is. Okay, special topic, shared platforms. What if you already have a donor or funder lined up and you just need a charity to issue a receipt or sign off? Okay, this framework of qualified disbursements of granting is not going to work for you. If your donor or your funder or someone who wants to give you real estate, for example, if you're a land trust or something like that, the charity is not allowed to issue the receipt and then turn around and give you the stuff. That they could lose their charitable status. Okay. This is where the direction and control rules are still relevant. That charity can issue the receipt and then turn around and create a direction and control relationship with you as shared platforms or trustee organizations have already done. So shared platforms can continue to do what they've done in the past. Okay, so comparing to direction and control, how is this framework similar? How is it different? So the end goal in both cases are similar. It's to ensure that resources are exclusively used for charitable purposes. That is the bottom line of all these rules. Make sure the resources are used exclusively for charitable purposes. The difference is that the charity does not need to call the shots at the end of the day. You can make the decision about how to further those charitable purposes and what the charitable activities are, so long as they further the charitable purpose. Vetting, in both cases, direction control and qualified disbursements, the funder vets the recipient, and they're looking at trustworthiness and capacity in both cases. In both cases, a written agreement is almost always needed. And in both cases, the reporting and record keeping must show that the resources were used exclusively for charitable activities. But the way the charity talks about it, the way you talk about it can be radically different. This is your work. When the charity grants to you, they are supporting you to do your work. We don't need to pretend, as we have done for so long under direction and control, that the nonprofit is doing the work of the charity, right? You're doing your own work and the charity is getting behind that. Okay, so is there any point in registering as a charity anymore now that you can receive these grants potentially? So the pros of registering as a charity is that not all funders will do qualified disbursements. And you kind of need to look at who your specific funders and your specific subsector are. Are they doing qualified disbursements? If the answer is no, there may be a much bigger rationale for you specifically to become a registered charity. There are far more flexible rules about how registered charities engage in social enterprise, both investments and what are called related businesses. So if you're operating some kind of social enterprise, it still may be relevant to become a registered charity as opposed to just a nonprofit. And if your funding model involves you issuing, tax receipts, as I mentioned, that's not something you can just get a charity to do, to issue the tax receipt and then give you the money through a qualified disbursement. So if you want to be able to issue tax receipt, if that's important for your stakeholders, charitable status is still relevant. What are the cons? As a registered charity, you're restricted to exclusively doing charitable activities. Whereas as a nonprofit who receives qualified disbursements, you could do lots of non-charitable things. You just need to make sure the project that's being supported or funded by the charity, that remains exclusively charitable. Number two, over time, their difference in access to funding will go down. So hopefully over time, funders will increasingly take up qualified disbursements. So the advantage of being a charity now may actually decrease over time. Thirdly, there's of course the cost of application and maintaining your charitable status, and there are significant reporting requirements. Okay, so here are 5 common things I've heard from funders who are hesitant about doing this kind of funding. We aren't allowed to fund NQDs. You just need to get them to change their purposes, and that's an administrative pain, but it's not impossible. We are worried we'll get too many applications. That could be a good thing. You need to make the case that they're missing out on you. You're crucial to them to accomplish their purposes. We're worried about the risk, and this is where a larger conversation needs to happen among funders about what risk means. It's a lot of work to change our processes. I hope what I've showed today is that all of these expectations are very standard processes. Many charities already have them in place. They may need to do very little to be able to fund non-charities. And finally, CRA makes us do it this way. Absolutely not. CRA itself says they're flexible. Okay, so with that, I would love to hear the questions.
Yeah, sorry to rush you along here. I just want to make sure that we get to a few questions before we wrap up. So the first one is not-for-profit affordable housing considered beneficial to the community?
So great question. Affordable housing in and of itself is not considered charitable. However, there are many aspects of affordable housing which could further a charitable purpose, such as affordable housing specifically for the aged or specifically accessible affordable housing. Actually, just yesterday, the national NC, the National Community Land Trust, the Canadian Network of Community Land Trusts published a guide, which we helped produce on charity law for land trusts. And I go in detail there in when affordable housing could be charitable. So I encourage you to check out that resource.
Okay. Is this really new rules or refinement of the rules with different vocabulary? Example, grants, bottom line, due diligence, and direction and control. And then in brackets, written agreement, records, risk, and other provisions.
Yeah, it's a great point. It is largely very similar. What's fundamentally different is that at the end of the day, the funder does not have to call the shots and does not have to take the credit. How important that is to your particular organization, that may be a minimal thing, or that may be very important.
Okay. If the not-for-profit to date is small and receives few to no grants, obtaining grants from charities can result in the not-for-profit becoming a public benefit corporation. What is the
Mhm.
impact of this to the not-for-profit?
Sure. So under the Ontario Not-for-Profit Corporations Act, there's a designation called Public Benefit Corporation, which if you've received more than $10,000 in gifts or donations from organizations or individuals who are not your members, employees, officers, or directors. So if you end up falling in this category, so there are some differences in how you do your annual financial reporting, and you can find more on this on our website. There are some rules around how you can distribute assets if you dissolve, and only up to 1/3 of your board can be employees.
Okay, our grant recipients are typically Canadian university or college groups, usually under $5,000 each. Duration mostly within one school year. None complain about direction and control. Are we missing some benefit from this new approach?
Um, Again, I would bring it back to the differences, who calls the shots and who takes the credit. If people are happy with direction and control, then you may only see a marginal difference in the change in rules.
I think we're good. I think those were sort of the questions. Does anybody have any other questions? Those are the questions I saw in the Q&A. And Terry has said, I was employed by CMHC many decades ago, and the NHA then had a requirement that a nonprofit housing corporation needed to be exclusively charitable to obtain funding as a nonprofit under the National Housing Act. No doubt the legislation has changed.
Yeah,
Cool.
I think that's right. But I appreciate that historical point. And thank you, Celia, for sharing that. It was a pleasure partnering. Sorry, I mangled CLT's name there.
Okay, I think we're good. I don't see any other questions coming up. Oh, of course, as soon as I say that. Microgrant program. Okay, we're exploring the idea of a community health center allotting a microgrant program to nonprofits via the regional drug strategy and an application to the Public Health Agency of Canada. Any additional thoughts to consider?
Um, so the nature of the activity, so healthcare, medical work often carries with it certain inherent risks. So that the nature of the activity itself may influence the risk assessment. One thing when thinking about the meaning of capacity to carry out an activity, some of the language online may make you think, oh, this person needs to be an expert in the kind of traditional Eurocentric way of thinking about expertise, meaning they have degrees, some official title, etc. But if you can explain why people's lived experience, for example, is the relevant expertise you need to be effective in carrying out your specific charitable purpose, and this may be relevant in a peer support kind of program in a drug context, for example, then that is the relevant expertise and capacity, but you need to be able to explain it.
Okay, I think we can officially let people go.
Okay, there are a few more questions in the chat. We still have a
I'll
few minutes. Hmm?
I'll note them down. Here, let's see. Where's the chat? Here we go.
So
Sorry, I saw so many thank yous and then I didn't see the other one.
yeah, so I see to the question, we are supporting startup companies. How would we further charitable purpose? We fall under promoting commerce or industry. So yes, and in fact, there's specific case law. If you check out the New Zealand guide on charity law in New Zealand, there's a chapter dedicated to promotion of industry. You will see there is case law where sometimes supporting startups is not charitable and sometimes it is, and it really depends on the details of how you support them, who's eligible to apply, etc. And also it depends on the local context of where you're supporting them. For example, if it's in an economically deprived area, then there's more of a rationale for that being charitable there under the guide, community economic development and so on. So while New Zealand law is not the same as Canada's charity law, it is very similar and the cases are by and large relevant. And we'll provide a link afterwards. But
Yeah.
if you look up Donald Poirier, New Zealand charity law, you'll find it. Okay, so with that, thank you so much for your patience and sticking through right to the end. We hope that you found this webinar useful, and we will email you the recording as well as links to key resources within a week. Take care and have a good afternoon.